live on television. When we spoke back in January and I asked you what would happen, you called it. You said they're going to overturn it. The initial case was just about Mississippi's ban at 15 weeks. But why did you get the early sense that the court was going to go all the way here?
Well, first of all, I've covered these nomination hearings for a really long time, and I've seen kind of in my book, I went and conservatives obviously were deeply disappointed by some of the what they see as failures of previous Republican nominees, and so there was a concerted effort to get solid judicial, uh, you know, confirmation of these nominees that had a solid judicial philosophy that was conservative, and it was clear to me that this bunch has that. The last three, for sure, and of course Justice Alito, and we knew where Justice Thomas stood. So, I felt like this was a group that was likely to have this conservative legal philosophy that would think that Roe versus Wade was absolutely lawless and an exercise of raw judicial power, as Justice White wrote in his dissent back in 1973. So, going into the oral arguments, that was kind of where I was coming from. And when you watch the arguments in this case, the Mississippi case, I thought it was pretty clear that there were at least five justices signaling that they were going to overturn Roe versus Wade. They believed that that was made up law. It was not in the Constitution. It had damaged the court, led to division in society, and it was time for the Supreme Court to get out of it. And so, to me, it seemed like it pretty clear at oral argument back in December.
Well, can you explain for just kind of court observers and the people just kind of reading the headlines this week, why is it that the conservatives, that those five justices felt Roe was made up law?
Well, because a conservative, and I mean, this also, the bottom line here is that elections matter, right? So, a Democratic president is going to look for legal scholars or law professors or lower court judges who has a quote liberal judicial philosophy. And that's a philosophy that's more willing to read rights into the Constitution to kind of suggest that, as Justice Breyer always said, it's a living Constitution. It has to evolve with today's standards. Conservative legal thought is that no, you don't, because if you do that, then it's just whatever the judges say the Constitution is based on their policy preferences. You have to look at the text of the Constitution, look at what the original understanding of that was by the framers, and what they were trying to get to, and potentially the history. And so that's the big difference in those two philosophies that you see on the court. And the five that we saw overturning Roe very much share that conservative legal philosophy that you don't read rights into the Constitution. And there is no right to an abortion in the Constitution or anything that suggests that was grounded in history or, all the other things that they would consider in evaluating whether it's in fact a constitutional right.
I'm intrigued about the role of John Roberts, who's an originalist in
Me
his own
too.
right. And, and his role, or I guess lack thereof, he tried for months to get one of them to join him in a middle ground approach, allow the Mississippi 15-week ban, but don't overturn Roe. What do you make of his concurring opinion? Why do you feel, what's your sense as to why he was unsuccessful here?
Well, because the other five thought we're not going along with this because, Roe was wrong and we need to correct it. And you're just, basically looking out for playing politics and worrying about what people might think and, the institution. And regardless of what people might think or the institution, we have to worry about the Constitution. So that's where the five were coming from. There was never going to be any kind of, it was clear at argument. Even Kavanaugh signaled at argument that this is how he saw this case, that the court was going to be neutral on abortion, not take a view anymore, and send it back to the states. Roberts is someone who, the second he stepped foot on that Supreme Court, really believed that he could convince other justices to rule in a more narrow way so that they might have consensus. So that would, do away with so many of these 5-4 decisions and just go as far as you might need to, but don't go all the way, and then you might get more people on board. Well, that was a failure in his first year on the court when, the court in a series of decisions turned sharply to the right on his very first year. The liberal justices initially thought, oh, okay, we like this new chief. He's talking about consensus and narrowly. And by the end of the term, one of the justices, who I'll not say, was complaining that, to John Roberts, consensus means that you agree with him. that, he wasn't really willing to kind of find consensus. He just meant, come agree with me. So, that's kind of where Roberts was right from the start. He always thought you should do things incrementally. He never wanted to like swing for the fences on some of these things, even though it's a distinction without a difference. He thought that the Mississippi law that banned abortion at 15 weeks could be reconciled with the core holding of Roe versus Wade, which of course bans abortion. Which of course says states cannot ban abortion before viability at around 24 weeks. So, like, I'm not really sure how those square up. But he said, well, we can throw out the viability standard and still uphold Roe. And, the other five were like, no, we can't. That's like, you're just now making up some other law, like some other standard, like just like Roe did, just like Casey did. So, they didn't write that, but to me, that's kind of what they were saying. So that's how we ended up there. I don't think there was ever a chance. Maybe I don't. I was trying to think. I don't think there was. I think the biggest question after we got that leaked opinion that showed where Justice Alito was going with this, that Politico reported there were 5 justices in the majority for this, that suggested that the chief was over here, and there's been all the speculation that the chief might try to peel off Brett Kavanaugh or someone else to join him and stop the court from overturning Roe. I don't think that was ever going to happen. That was not going to happen. And the only question to me was whether Roberts would just drop all that and decide, okay, I see the writing on the wall, I may as well join the 5.
Just one audio note. I think, are you hitting the table at all, Jan, as you're talking?
Yeah, is that bad? Sorry.
I think it's pretty subtle.
Yeah, I'm banging on the table.
I know you are. And I think your cell phone, some ringer went off at some point.
I know, but I don't know how to turn that off. It's on my computer.
Okay.
How do I turn it off?
What app is it? Slack?
No, it's just my messages. Are you
you
recording
like your text
this?
messages? I am recording this. Yeah, but I can slice it out.
Okay.
If you just close, is it a MacBook? If you just close out your messages, it'll do you know hold that?
I tried to.
Hold it down.
Okay. Sorry.
No, it's okay. Don't
Quit
apologize.
messages.
There you go.
Okay. Maybe
All right,
that'll
awesome.
work. Well, all right, are you still not recording?
No, I'm recording. We're gonna slice this up.
All right, so is this like what you're interested in me saying?
Yeah, I love this stuff.
You want me to be like more concise?
No, I think this is great.
Okay.
I think this is fascinating.
Okay.
Are you if you're a podcast person, people like this. People, want to nerd out on this stuff. On the Roberts question, it seemed like one of the things conservatives say here is that, Roe was a made-up standard, and then Casey was another made-up standard. And then Roberts, in his concurring opinion, talks about a new standard he was thinking about called reasonable opportunity for abortion. And so effectively explain what that would have meant, and again, why the rest of the conservatives were unconvinced by, Roberts's philosophy.
Just remember, the conservative legal movement believes that Roe is one of the most egregious mistakes in the history of the Supreme Court. There are several others that you can think of, but that's one of them too. And so, the idea was they made this up. They created this whole standard that's not in the Constitution about viability and when women could and could not have a constitutional right to abortion. And, they went through the Roe court, kind of read, as Justice Alito said, like something you would see in a policy paper, not from a court, which is supposed to be looking at the Constitution or the law. And so here comes Roberts and says, well, okay, fine, viability, that was really a bad idea. How about we do this standard, which is, let's just say a woman's right to choose is, basically she has enough time. 15 weeks, that's enough notice to choose. So that's not an incursion on the right to choose. So to the conservatives, that's just another made-up thing like Roe was, like Casey was in 1992. And, they weren't going to go along with that.
So just to close the conversation on Roberts, do you call this a 6-3 decision or a 5-4 decision or a 5-1-4 decision? Yeah.
It's 5-4. It's 6-3 in that John Roberts would have allowed the Mississippi law, and that would have been a significant story for a day or two. But it's 5-4 on whether or not a woman has a constitutional right to an abortion. That is what the 5 and only 5 agreed on. this decision, to me, the historic sweep of the decision, the reason you're seeing protests across the country, the reason that states now will be able to ban abortion if they want to, that was a decision that was 5-4.
Got it. Even though Roberts doesn't officially join the liberals in their dissent.
Right. He writes a separate concurring opinion, concurring in the judgment, which is the outcome, which is that Mississippi's law is upheld. He specifically says throughout his opinion that he does not think the court should overturn Roe and Casey.
Got it. To the dissent now, the three liberals on the court, what was their constitutional argument? What do you make of the way they wrote their opinion? And what does it mean for, future cases when it comes to, sorry, let me ask that again. So now to the dissent, the constitutional argument that the liberals made, the three liberals on the court, what do you make of their opinion, their argument? What was their case for upholding Roe?
Well, first of all, before we talk about like the specifics of the reasoning of the dissent, I think it's really interesting to point out that it's highly unusual. Like I can't remember the last time I saw a joint dissent. Typically, the individual justice will take on a dissent, and then the others will join it. And I really expected in this case that we would get three separate dissents. I thought Justice Breyer would focus on stare decisis. I thought Justice Sotomayor would focus on the harm to women and the reliance women might have shown in relying on Roe and Casey and organizing their lives. I thought Justice Kagan would focus on the institutional concept of this, and then they could all just join each other and all that. Instead, they issued a joint dissent that they were all united on, which is unusual. And I thought, really kind of a statement like we are united on all of this. And it was similar to what we saw even in 1992 when the three justices came together to refuse to overturn Roe in the Casey decision. Of course, that's Justice Kennedy, Justice Souter, and Justice O'Connor. So there was kind of this weird symmetry there too. And then they all came together and made all of those points in that one powerful dissent, which was, stare decisis. The court typically doesn't overturn past decisions, certainly not ones that are 49 years old and people have come to rely on, that have, been essentially protected. Even again in 1992, the court refused to overturn it in Casey. We saw the dissenters talking about their concern about the legitimacy of the court, the institution, the harm to the republic, the harm to women, all of that in that one dissent. So yeah, I mean, it was a powerful dissent. They also raised questions in that dissent about where does this stop? Are other rights in danger, such as that are grounded in the same constitutional provisions that Roe was in the 14th Amendment? Kind of the concept of liberty, and Roe, of course, being a right to privacy. Some of those decisions, like a right to contraceptives, a right to same-sex marriage, they raise questions about that. And I think that we have seen, because of Justice Thomas's separate opinion, we've seen a kind of hysteria about whether or not those cases are next. Right to contraceptives, right to same-sex marriage. I mean, they're not. The court, and I mean, I don't know if I'm veering off on another tangent.
No. I wanted to get to this next. So we're talking about three precedents here, Jan, that are kind of predicated in that same right, or the Obergefell decision on same-sex marriage, the Lawrence decision on same-sex relations, the Griswold decision on contraception. Clarence Thomas and his concurring,
and another contraception decision, Baird versus Eisenstadt. I mean, there's a number of cases that are kind of grounded in the same constitutional right.
And this Thomas decision is dominating the headlines. He basically was like, let's reopen all of these. Let's reconsider all of these. The majority decision, of course, written by Alito, says this is only about abortion. Let us be clear. This is only about abortion. And I think even Kavanaugh and his concurring also reinforces that. So, So you have the liberals saying other stuff is next. You have Thomas saying, yep, other stuff is next.
No, well, he says, I would like to I think those cases we should rethink as well, or maybe, leave the door open for that.
So interpret that for, millions of Americans that aren't, kind of studied in constitutional law. But what does it all mean? And when you say, like, we don't have to worry about this stuff, that someone who's recently had a same-sex marriage, like, don't worry, Obergefell is safe. Why do you feel that way? And what exactly was Thomas saying with his opinion?
Well, Justice Thomas has always been, off on a trip of his own on some of this stuff. This is not the first time that he has suggested that he thinks that line of cases is just made up. It's like finding implied rights in the 14th Amendment. That's not what the court should be doing. You got to look more to the text, all the kind of stuff that we talked about. He's the most conservative justice on the court, the staunchest originalist, even to the right of Justice Scalia, when Justice Scalia was on the court, much more willing than any of the other justices to consider precedent. So it wasn't surprise. I don't know why Thomas felt compelled to write that separate opinion that no other justice joined, but it's not surprising that he believes that. He said that before. And he thinks that the court, he basically thinks every decision should be up for reconsideration. What is surprising is how there's just been this collective freak out, and refusal to acknowledge what not only the majority says about how we could not be more clear. Those cases are not in doubt because abortion is different. It involves a life. Unlike a right to contraceptives, unlike a right to same-sex marriage, abortion is different. Then you see Justice Kavanaugh, as you mentioned, writing that separate concurring opinion saying abortion is different. Those cases are not in doubt. So, the court, you can't change the law, overturn cases, unless you have 5 votes. You got to get to 5. So right now we have 1 vote, which is Justice Thomas. And we have all the others saying, the other conservatives who were on this opinion saying, this is not casting those cases into doubt. We know where the liberals will stand on that. That's 3. We know where the chief would stand on that. That's 4. So, it is such a sideshow. And it is interesting to me that we have an opinion that a majority of the justices said a 49-year-old precedent was going to be overturned. That will have tremendous impact on women in many states across the country, poor women in states like Mississippi and Alabama, where there will be no abortion allowed whatsoever. And for some reason, lawyers, law professors, media analysts, cable, Twitter, they've all decided they're going to focus on what's next. What's next? When the court has said that is not next. Isn't this decision, Dobbs, isn't that significant enough to focus on what this will mean for women? We have 5 justices today that is literally overturned Roe, said states can ban abortion if you want to. And now we're off on this trip, like talking about what's next. Contraceptives. What about same-sex marriage? That's not next. Let's focus on what the court did and what's going to happen now to women. And then to see responsible people, lawyers, law professors suggest that what about interracial marriage? Well, that's grounded in an entirely different part of the Constitution.
Right. Some people brought up, it's interesting Clarence didn't bring that up because he happens to be in an interracial marriage, so obviously he would want to overturn that precedent.
That's a totally different part of the Constitution. So anyway, that's where I come down on that.
Got it. So that's from your legal perspective, you feel that some people have been more than irresponsible by saying that these other rights or these other cases are at risk. And Clarence
the reason
was
I can say that, yes, I do feel that way. I think that the commentary and coverage has been irresponsible and inflammatory. And the American people believe it. And CBS polling shows a majority of the people now think that it's likely this Supreme Court will overturn those cases. And that is at odds with what the court has said. That is at odds with what these justices, a majority, have done. We have 1 justice saying that, not 5. And we're just wasting a lot of, airspace and, mental energy instead of focusing on what the court actually did, which is literally one of the most historic decisions in the history of the Supreme Court, and will have tremendous impact on women.
Yeah, let's talk about this, because effectively the court has now handed this to the states, and there's a whole bunch of issues that are going to be hitting the court. I mean, if we thought we heard the last of abortion court cases with this decision, that's definitely not the case. Issues like abortion pills, interstate travel, the legality of centuries-old trigger laws. Um, as you look at some of these issues that are now going to be coming up, and already are in the court system in some of these states, what are you watching here? And from your perspective, what do you think will make its way back up to the Supreme Court? And what are the cases that are most interesting to you?
I think that the idea that states could prohibit women from traveling to other states to get an abortion is one that we're going to see. I think we'll see some states try to prevent that, and that'll go through the legal system. And my guess is that won't get to the court because the lower courts will say that's unconstitutional. That violates your right to interstate travel, which is clearly in the Constitution. And the Supreme Court is not going to allow those kind of laws if it does get to the court. And again, I mean, Justice Kavanaugh writes that in his concurring opinion. There is not support for that on this court. Um, the other questions, I think a really interesting question is, can states ban women from ordering abortion pills through, getting abortion pills through the internet and then through the mail? Obviously, states are now trying to do that. South Dakota, for example, among others. That raises interesting questions about the role of the federal government versus the states and preemption issues. And it also raises enforcement issues. How are states going to know what women are getting through the mail in some like little packet? I mean, are they going to start going through their mail? Are they going to have mail carriers like, oh, that looks suspicious, I better put that one aside? I mean, it's not unworkable in practice. And I mean, it's not workable in practice, those kind of laws. And I think that that's also going to be challenged as, violating kind of it'll be a federal state conflict. So, I mean, there are a number of legal issues that I could see going back up to the court. The question of whether a fetus has rights, that's another big question. But the bedrock issue of whether a woman has a constitutional right to abortion, that's done. That's over. This court is going to be this court for some time. And while 5 justices voted to overturn Roe versus Wade, if there were another challenge, let's say one of those justices left, the Chief Justice John Roberts, now that it's been done and Roe is history, he's not going to vote to overturn Dobbs. So we can count him as a 6th vote. So right now there are 6 votes. Sorry, I banged on the table. There are 6 votes.
For those of you listening, Jan is very passionate. So if you hear a slight thump,
Sorry.
it's her reinforcing what she's saying.
Listen, it's been a long week, Mosh. It's been a long week.
I know, Jan, and we have another week upon us, and the court isn't done yet, and we'll get to that in a second.
I know. So at any rate, right now on this Supreme Court, there are 6 justices who are going to say there is no constitutional right to abortion. Roberts wasn't willing to go that far before Dobbs. He thought they didn't need to swing for the fences, but now that they have, he's going to be on the team. So he's not going to vote to overturn it if it's ever challenged again.
Interesting. I was struck by one thing you said on CBS Face the Nation this morning, that you said the conversation about abortion has become more punitive. It has turned neighbors effectively into bounty hunters, especially that Texas law.
Right.
What can the courts do about that, and how exactly did we get here? And I was especially interested in kind of how this Texas law, where effectively you're tattling on and you're suing people over abortion, that hasn't been fully figured out yet, right?
No, I mean, that one's still in the legal system. What's the problem with that law is the way it was written. The courts haven't had a real opportunity to jump in because it hasn't actually come up where somebody's tried to collect their money. I mean, I think it recently has, and now that's going through the system. So it was written in a way that made it very hard to challenge until it actually kicked in and somebody actually tried to collect their money and tell on someone. But when we think about I mean, you ask what can the courts do and all this kind of stuff. And I think that some of these questions, the courts can't do anything. I mean, states can ban abortion now. Texas had that 6 week ban. The Texas government wasn't going to enforce it. State officials weren't going to enforce it. They were going to let citizens enforce it and get $10,000 rewards if they found someone trying to get an abortion after 6 weeks. Well, I mean, now that there is no abortion in Texas, or there won't be anymore, there's not much use for that law. The state will just go after them. So, the question I think more broadly is, what is the role of our political branches and the people? And it's really interesting if you look back to 1973, right before Roe was decided. Of course, it was decided in early 73, but so let's say 72. States were really moving in the direction of liberalizing their abortion laws. There had been kind of a suggested nationwide law that would have allowed for 3 different exceptions to abortion bans, and states had started passing those. The first abortion was illegal across the country, illegal until 1967. That's when Colorado passed the first law saying that they would allow some exceptions to their ban, including like life of the mother, rape or incest, those kind of things. Other states soon followed. And then 4 states, including New York and Hawaii and Washington State, I think Alaska was the 4th one, they just said, we're going to legalize abortion completely. So all this was happening in a period between 1967 and 1973, right? So you had at least 17 states really starting to liberalize their laws. And those laws allow those laws, including Mississippi, including South Carolina, including Florida. I mean, these kind of now what we think of as these bedrock red states, some of those were liberalizing their laws, allowing for exceptions for rape or incest, among other exceptions. And so when you fast forward to today, I mean, Roe stopped all of that, and that's a big conservative criticism. The political and Justice Ginsburg also criticized Roe for this. The political branches and the conversation in the public was kind of moving in the right direction.
So interestingly, so if Roe ends up getting decided the other direction, saying it is the states, it is up to the states.
Yeah,
the thought is that
that way anyway.
It was inevitable that they were liberalizing their abortion laws.
Right, and so even then, Judge Ruth Bader Ginsburg she was quite critical of Roe for, basically short circuiting the political process. And even, I mean, President Obama, not even speaking about Roe, but just talking about how it's always better to build like consensus among the people instead of having the courts just dictate like a nationwide policy, because then people will resist it. And that's what happened. I mean, it short circuited the political process in some ways. And so now if you fast forward to 2022, 49 years later, we can see some of the laws that states have passed, trigger laws that will take effect in weeks, months. And some of those laws are much more punitive and restrictive than what states were considering in the late 60s and early 70s. Some of those laws don't allow exceptions for rape or incest. And then we have these other laws that kind of, like I said, I mean, turn neighbors into bounty hunters, looking to punish women who and criminalize abortion. I mean, make it a crime if on the woman. I'm not saying this right, but punish the woman, charge the woman who might have an abortion. None of that was in the works in 1972 before Roe. So in some ways, the debate over abortion has become more punitive than it was then. Now, on the other hand, I mean, things are obviously better for women. Abortion wasn't really talked about, and that people were like, "Oh, we can't talk about that." Like it was not a topic. People were not showing support for women who needed an abortion. They were certainly not trying to create networks to help women get abortion. There was no medical abortion. Half the abortions now are through pills. So women had so much fewer options, in the before Roe versus Wade. I mean, please don't misunderstand what I'm saying, but I do think it's interesting that today we see this kind of undercurrent, that there is this kind of drive to try to punish. And that's what I meant when I said the conversation in some ways and the laws have become more punitive.
Yeah, I'm struck by the history here because I just want to address one more thing, which is the Roe decision was a 7-2 decision. 5 of the justices were appointed by Republicans, including the chief. How you've covered Washington and politics for a long time. As briefly as possible, can you explain how did we get to the point? Oh, at the
My
sound of the
connection
bell.
is iffy, but I literally swear I turn it off. I'll get my kids to help me with that next time. Oh, sorry.
No, it's all good. Explain how we got to the point where it was a 7-2 decision by majority Republican justices and the state of conservative politics and how we got to where we are today, where a conservative majority court overturned that decision.
Well, because the right decided that, I mean, in the early 90s, that they were going to be much more rigorous about screening judges that they wanted on the Supreme Court and on the lower courts. No more Souters, no more Kennedys, no more surprises. Justice Souter, obviously nominated by George H.W. Bush, you know, everyone thought they were so smart because he was a stealth nominee, and they were going to sneak him on the court, and he wasn't going to go through that horrific confirmation process that defeated Robert Bork. Remember, Bork made no secret of his views. So, Republicans were like, aha, we found this guy no one's ever heard of. He's like a hermit up there in New England, and we're going to put him on the court and, slam dunk. And it was just the opposite. I mean, he wore a three-piece suit and held the door open for women, and, he looked conservative, but he
Right.
was not
Souter
conservative
was
at all.
nominated by a Republican and turned out to vote with the liberals.
One of the most liberal justices on the court. So, because he did not have a philosophy when he went on that court, he'd only been on the lower federal appellate court a year, less than a year. And so, Republicans weren't going to make that mistake again. They were going to look for justices with proven conservative legal ideologies. And that's what they've done.
And the issue of abortion had become much more important to the Republican voting base from where they were in the early
Yes,
70s.
I agree with that. I had to think about that for a minute, but yeah, no doubt. And that's been a strategic decision by anti-abortion forces, which there were two major setbacks for them, and in each one they got stronger. 1992, when the court failed to overturn Roe versus Wade by one vote, and at the very last minute, when Reagan appointee Anthony Kennedy changed his mind and decided he just couldn't do it. So close in 1992, one vote away. And then in 2012, when Mitt Romney did not really embrace the pro-life movement, he and other Republican politicians were perceived as just paying lip service, where they would just, we don't have to talk about your issue. Come on, you're not going to vote for Democrats, pat you on the head and go stand over there. And the movement really decided, and led by the Susan B. Anthony, now called Pro-Life America, I think it's their name, they've tweaked it a little bit recently, decided that they had to become more politically strategic, and they had to elect more people to office. And as the founder, Marjorie Dannenfelser told me, and this piece is airing on Monday on CBS, we decided we had to reward our friends and punish our enemies. And as a result, in 2014, they defeated 7 pro-choice candidates. And so they were able to kind of bolster the Senate and some of the other state legislatures. And that, of course, paves the way for more judges.
Was there more organization on the conservative side than the liberal side? Like, if you could kind of lay out, the pro-choice side, even with the leak in early May, there still seems to be some level of shock here.
That's the thing, Moshe. I mean, I completely agree. We knew. I mean, everyone has been saying. I mean, I wasn't the only one that said that Roe was history. You kind of had a sense of it before the argument based on how I think these justices view the proper way to interpret the Constitution. But after the argument, I think it's very hard to say this court is not going to overturn Roe versus Wade. I don't know how anyone could have said that. Everyone should have known this was coming. And then we got the leak of that opinion. That was what, 2 months ago,
Right,
that
early May.
showed that this court was going to overturn Roe. No one, certainly in politics, certainly in Washington, should have been surprised by what happened on Friday. But it almost was like it caught the White House off guard. Everyone still was just like, they cannot believe the court did this.
Yeah, there were anecdotes that some reporters were catching White House staffers kind of walking down the driveway to get coffee Friday morning and being like, "Hey guys, there's a thing happening over the court related to Roe v. Wade," and staffers like running back into the West Wing.
Like, not even thinking that was going to happen.
Yeah. But you spoke a bit about the confirmation hearings, and I'd love to get your thoughts on the process. So Susan Collins says she feels upset and misled by what some of the conservatives said. You have folks even like AOC who are saying we need to begin impeachment proceedings, that they lied, that several of the conservative justices, when they were going through the nomination hearings, said Roe was settled law. You cover these confirmation hearings. Explain what they were saying. Explain, is it fair to say they were lying? This is
No,
perjury.
no, no,
Um,
no,
ex-
no, 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 no.
okay, so explain, explain why Susan Collins feels misled and upset.
Well, I'm sure she
Um,
feels misled and upset because she's in a world of trouble now.
yeah.
I mean, her, voters in her state weren't keen on her voting to confirm Brett Kavanaugh or Neil Gorsuch or Samuel Alito, who she also voted for, by the way, the author of
Hmm.
this opinion. So, I'm sure she's concerned about that. But look, there is there is boilerplate language that all Supreme Court nominees use. And when they're ever asked about precedent or cases or how they may rule, they're coming on there and they're looking at this from the outside. They're lower court judges, they're law professors. And when they're asked, is Roe settled law? Well, the answer is, of course, Roe's settled law. But that doesn't really mean anything. It's settled law from their perspective in that moment, but it's settled law only until the Supreme Court says it's not.
Settled
So,
law does not mean permanent, forever,
no,
untouchable.
it means, yeah, right then, an appellate court judge to an appellate court judge, it's settled law. Whatever the Supreme Court says, that's the law. They have to follow it. But it doesn't mean that it's settled permanently. And if you look at, even there's questions that sometimes they'll try to, I mean, not that they ever ask any good follow-up questions. They just read, most of them just read what their staffers wrote, I
You're
think.
talking
But
you're talking about the way senators ask questions of the
yeah,
justice. Yeah.
yeah. So if they had any, sometimes they'll have some decent follow-ups. Some of them do, so that would be like, well, yes, you're saying it's settled law, but if you were on the Supreme Court, would you view Roe as settled law? Would you consider it was settled law and could not be overturned? And then that's when they all pull the same, well, that's an issue that might come before the court, so I can't answer that. And they all say that. Justice Ginsburg said that. She kind of started it as the Ginsburg standard. And that is, I mean, it's fair enough. You don't want nominees to be weighing in on cases before they've had a chance to like get the briefs, the arguments, all that. Okay, fine. So to me, this is much ado about nothing. And if you're going to impeach Kavanaugh and Gorsuch and Barrett or whatever, then you're going to have to impeach all of them because they all
That
answer it
that
the same way.
they all
And
answer it
maybe
the same
people would like
way.
to do that. Just start over. Just start the whole court over. There may be some who'd be like, yeah, let's do it. But
So
that's a non-issue.
so to the non-legal person, when they say settled law, that doesn't mean permanent law, it doesn't mean untouchable. So this idea that like, well, they said it was settled and then they overturned it, there's not a inherent contradiction there.
No, because they're being asked that question as a nominee to the Supreme Court. And where they are in that moment, they're still an appellate court judge. And if someone asks you, is Roe settled law? You would say, yeah, it's settled. What's today? Yep, it's settled. But that doesn't mean that when you get on that Supreme Court, you might not rethink it. So if you ask the next question, what's it going to mean to you as a justice? Then you would get an answer that could be very different. But of course, then they would just say, well, we can't answer that.
Right, which
That
is
might
not the
come before us.
mashups, which are not the mashups that are going viral on social media this weekend. The I can't answer it. It's that previous. It's the answers to
So
that
I will
previous
tell
question.
you something about social media, and what I have done. I mean, obviously, this is one of the most contentious decisions in Supreme Court history, Roe, and now Dobbs, another one of the most contentious. And I decided that my goal in all of this was to just report what the court was saying, consider what I knew from my reporting over the years, and be as clear and objective and fair as possible. And as a result of that, I have not looked at Twitter in weeks, weeks.
Let me tell you,
So,
you haven't missed anything, Jen.
because I don't want to know, I don't want to be influenced by like what's much of which is nonsense.
Yeah.
It's just nonsense.
I think as frustrated as you are with where the conversation is, you would have been even more frustrated to be on Twitter these past couple days, and especially these past couple months. But one to put a pin in confirmation hearings. Do you think this changes anything?
No, no.
No.
I think the court hopes it will. And of course, Roe versus Wade has had a tremendous impact. I mean, the confirmation hearings now and have been for years are largely about abortion. Even the questions are kind of the opposition. It's so much about abortion.
Yeah.
And I think the court in this decision is saying, the court's out of it. The debate should be in the states. And I'm sure they're hoping that that will take the abortion debate out of confirmation hearings, but I don't think it will.
Well, it remains to be
That
seen, and I
genie's out of the
guess
bottle. That genie's out of the
and
bottle.
I guess we have a relatively young court here, though. I guess is it Clarence Thomas is sort of the senior member of the
Yeah,
court
he
now,
just had a
right?
birthday last week.
And do we see a scenario where any of them retire, sort of Sandra Day
No,
O'Connor style, or they're all in it to
no,
win it? Okay.
no. I mean, well, they would never retire now. They're certainly not going to let Biden nominate their replacement. The
Right.
question is, um, you know, is there some other reason, health reason, personal reason that they may step down? But there's no one that's going to step down. And even if one did, it wouldn't affect Roe. Roe versus Wade's not going to magically come back because Roberts is now going to be on the Roe's history team.
So we have this patchwork of laws now. A couple of the other issues that have come up that people are asking about on social media, etc. And
I don't
I don't
know. I wouldn't know
I
about that.
well, I was going to ask you. I was going to ask you. I know you don't have a command for every state and what they're doing right now, but two things are in regards to IVF embryos and then ectopic pregnancies and some of the medical procedures. What is your sense of how states, even the reddest of reddest states, might be handling those issues?
Well, I mean, I think that's going to be very much up to, I like all of this is, it's going to be up to the state legislatures. The court has said there's no constitutional right to an abortion. So if a state wants to ban abortion in some of those circumstances, then, you know, like ectopic pregnancies, you're going to have to take that up with your state legislator. I would be absolutely shocked. And we'll see, it'll be interesting if there's a groundswell of support to ban IVF or to ban an abortion in the case of an ectopic pregnancy, which of course is potentially life threatening.
Right.
So, and I think that one thing that'll be interesting to look at is how some of these states actually react, because for so long we have been in the situation where Republicans could, some of them, like almost pander to their base and push the most extreme restrictions on abortion. And there was no political cost to them because they could, show the base if they were there with them. But then in the back of their mind, they're like, yeah, but you know what? The court's going to overturn that. So I can just say whatever I want because this is never going to become law. And so they didn't have to worry about the political consequences of, enraging people for some of these extreme measures. And so now they can't do that. So I think that it will be interesting to see if legislators in some of these states actually continue. They will in some, of course, and already have, but will continue to take some of those extreme positions. And if they do, how voters will respond, how
Yeah,
women will respond.
it is fascinating because you're saying the issue now Republicans actually have to be responsible for what they say on abortion, because for so many years they were also able to then push it to Democrats, being like, what do you think about late term abortions, what do you think about X abortions? And
Hmm.
Democrats were having an internal fight within the party. Even like Joe Biden, when he was a senator, at some point he voted against late term abortions. And so it was an internal Democratic issue for so many years, and now roles are reversed effectively. That's
I think it's going to
Republicans.
be a Democratic issue too, though,
Yeah.
because you're going to see And I think I mean, we'll see again, but I think one concern for both parties is trying to go too far. And for Democrats, that means potentially allowing that gives Republicans a good talking point, right? Allow no
Right.
restrictions on abortion. Ask for state funding to pay for abortion. Ask for state funding to help women travel to your state to pay for abortion. All that might be a bridge too far for people and in those states, and it certainly would give Republicans a way to present Democrats as extremist. And then on the
Yeah.
flip side, Republicans, when you start talking about banning IVF and not having an exception for rape and incest, and that again is an issue that Democrats could use if they go too extreme.
Yeah, looking at your CBS News poll that was out over the weekend, there's a lot of nuance when you actually ask. Actually, I think it was the poll from May where you ask people, okay, how many people agree with a 1 month ban? How many people agree it should be legal through the first trimester, through the second trimester? There's lots of shades of gray here when it comes to how the American people actually feel about the issue of abortion.
Right, and that's been consistent through the years. I mean, Pew does a really, in addition to CBS, of course, but Pew does a really exhaustive poll on abortion. And if you look, it's generally most Americans support Roe versus Wade, don't think it should be overturned. But then when you go into the tabs of that poll, they break it down to ask, should abortion, be legal after this, or would you support a 15-week ban? And the vast majority of the American people in that polling would support a ban on abortion at 15 weeks, which is what, 3.5, 4 months, and
Yeah,
that of
and
course is completely inconsistent with Roe versus Wade. You
right,
can't ban abortion under Roe before 24 weeks, and even then you have to allow so many exceptions that it actually is really much beyond viability.
right. For folks who are unaware, the U.S. had one of the more progressive abortion policies for many years under Roe, 22 weeks. The vast majority of Europe, Western Europe especially, they're all between 12 and 15 weeks, effectively.
Right, right.
Uh, um, the reputation of the court is
And by
something
the way,
that,
Mosh, that is what
yeah,
polling suggests that Americans would support. But the question is consensus on abortion possible? And I don't see any evidence of it yet. I think Virginia is going to be a really interesting state to watch.
yeah.
The Republican governor there has proposed a 15-week ban, maybe as much as 20. Um, you know, I see no evidence that there's going to be
These
any kind of
these
consensus.
purple states are going to be interesting to watch. The
I
Wisconsins, the
agree.
Michigans, the North Carolinas, where you have
Even like
Democrats in the
Georgia, some of the,
yes.
yeah,
Though I think Georgia's even considering something more restrictive right now, but especially given kind of the increasing strength of Democrats in Georgia. So like the
exactly. Georgia will be an
um,
interesting state.
so the just before the decision came out on Friday, a poll came out that showed that 1 in 4 Americans now have confidence in the court. 3 in 4 Americans no longer have confidence. I think it was a Gallup poll. 25% of Americans. It's the lowest in the poll's history.
In what? I
Um,
couldn't hear you.
it have confidence in the court.
Oh,
25% of
confidence in the
Americans,
court.
only now 1 in 4 Americans now have confidence in the court, according to a poll that was out on Friday. The lowest in Gallup history. How seriously is that something they take inside the court? Is that something
Oh, I
the
think they
justices will
take it.
discuss? Yeah.
Yeah, I mean, I think the Chief Justice, certainly Justice Breyer, they take that very seriously because Justice Breyer would always say to the court, they don't have a standing army. Like they don't have a way of enforcing their decisions except for, people have to respect them. But the court I mean, this is a low point, but they've had low points before. But the one thing about the court is that it has had more respect than other institutions, which of course always are well below 25. They're down
Yeah.
in the single
Well,
digits,
yeah, I mean, they're starting to approach
in the
Congress,
media too,
used
by the
car
way.
salesmen, the media,
Media,
lawyers. Yeah.
Congress.
But
So
how
25%, hey.
hey, we got 1 out of 4 Americans. But
Take
how
that, Congress.
how do they go about? Is there a way to reverse it at this point, or is that just something they have to live with? That we live in a time where the majority of Americans have lost trust in most major institutions. So welcome to the club, Supreme Court.
That's a that's, I think, something that my guess is it's not going to change for a while. I mean, you've got to think about what's ahead for the court. This week we're going to have a case on school prayer, so a big religion case. We're going to have a case, a narrow technical case, but it does address climate change and the regulation of greenhouse gases around power plants. So, that's going to be, perceived as hostile to climate change. And then next term, they have a case about affirmative action in college admissions that I feel certain they're going to strike down and not allow. They have a case on gay rights and whether or not artists and designers can refuse to create content for same-sex couples or put on their websites that they don't agree with same-sex marriage. It's a free speech case. So there's a voting rights case. So we have a situation now where last week alone, the court dealt with guns, abortion. This week, we're going to have religion and climate change. Next term, we're going to have race, gay rights. So, I mean, it's hard to almost think of what's another contentious, divisive issue? What have they missed?
I was going to say that pretty much covers it in terms of kind of hot button social issues. So if you come from a more progressive viewpoint, I says,
Yeah,
it sounds like you're saying buckle up, folks.
exactly. That's, I mean, if you are outraged about last week's decisions and we see the protests sweeping the country, wait till next term.
That brings me to one of my last questions here, which is security. I mean, we obviously saw the man who was arrested outside Kavanaugh's house, threatening to kill him. Incidentally, had some mental health issues. Clearly, he called the authorities on himself.
But only after texting his sister and telling him what he was about to do. And had she not gotten the text and called him immediately and talked him off the ledge, told him what to tell 911 when he called, and you can see it reflected in the language he uses in the transcript, that if she had not responded to that text, it could have been entirely different.
So what's being done about security for the justices at this point? Did the legislation go through on Capitol Hill, and how concerned are they? Yeah,
it did. But I mean, I think there is concern that there just aren't enough resources. I mean, even the alleged attempted assassination of Kavanaugh. This guy got out of a cab at 1:00 in the morning, dressed in black, carrying suitcases that were, that included, among other things, a gun, ammunition, zip ties, a knife, pepper spray. I mean, all that was in his bag. He took through security when he left California. But the U.S. Marshals didn't stop him, watched him get out of the cab, made eye contact with him, and then he wandered around Kavanaugh's house for 45 minutes. So the only time law enforcement got involved was after he called 911 and the county police came.
Do you think
so the point is there clearly are there clearly needs to be perhaps more security and training, and I think there already is. That was kind of a wake-up call.
Do you think more transparency from the court, and by that I mean like cameras in the court, or just seeing these folks speak out more often than these kind of random speeches and the interviews that they do around book releases? Do you think that would help them potentially connect with?
I do. I mean, just covering the arguments, you can see they're like so engaged in these complex areas. I mean, issues of the law, they have different views, but they're all engaged in it. I mean, just watching them, it's a shame to me that more people can't see how they do that, and how it is something that actually, it's 9 really smart people. You might not agree with a word half of them have to say, but they're engaged in this kind of pursuit of reading the Constitution the way that they think it should be read, reading statutes the way they think those statutes should be read. And, I think it reflects well on the institution watching them at work. But so, yeah, I mean, I do think that would be helpful.
And yet, what are the odds that we ever see cameras in the courtroom?
0.
And that's because tradition?
Yeah, and I mean, I think that they worry that people will grandstand. Lawyers will grandstand. Judge Ito really didn't do anybody any favors in the OJ trial.
It's still the Judge Ito effect nearly 30 years later.
Yeah,
huh?
And I also think they like their anonymity. And certainly now, when we see the enhanced threats to the justices, I think they like their anonymity.
And last but not least, we first learned on how they would rule here with the leak in early May. There's been an investigation that's been going on. What do we know about that investigation? What has changed?
Nothing.
Will
We
we
know nothing about
see?
it.
Will we hear who the leaker was? I mean, what's your sense of
No,
that?
my bet is we will never know, and the court may never know who leaked that. And maybe it was an unintentional leak. Maybe someone felt they had to share that opinion because they were so outraged or upset or wanted guidance. And
You think the
maybe
leak came from the left? You think it came from the one of the three?
that's my gut. But that's only that's largely because I think that uh, conservatives are not big fans of the media and certainly not Politico. So I would find it surprising that they would choose to leak to Politico.
So even the publication that was leaked to is evidence of who the leaker might have been.
Not necessarily, and no
Yeah.
one has any idea. And if you're just kind of looking, trying to put clues together, that seems to me there are other publications that a conservative might go to,
Got it.
whether it
So, so
was,
so that's an investigation that Roberts is keeping in house and will be kept in house, and unless there's
yeah,
another leak about the investigation or Politico names their
they
leaker.
never know, and
Yeah.
the court may not get to the bottom of it.
Yeah. Jan Crawford, thank you so much for
Thank you,
your
Mosh.
insight and perspective, and